Be ready. Start. Another aspect which deserves to be clarified at the outset is that the orders impugned in these petitions have been passed by the courts below by virtue of the powers conferred under Section 143A of the Act during the trial and under Section 148 of the Act during the pendency of appeal. Both these sections were not in existence in the Act earlier. Both these sections were added via Amendment number 20 of 2018. In none of the petitions, the wires of these provisions are under challenge. Hence, this court is proceeding on the presumption that the sections introduced by the Amendment Act are validly operating law. The only challenge raised by the respective petitioners in all these petitions is that since the Amendment Act has been enforced with effect from 2/8/2018, therefore, these provisions cannot be made applicable to the cases where the trials for offence under Section 138 of the Act were already pending or where the appeals have arisen from such trials which were pending on the date of the enforcement of these provisions. Hence, in essence, the grounds for challenge in all the petitions is that applying these provisions to the cases already pending before the courts would tantamount to giving these provisions retrospective operation, although the Amendment Act does not prescribe for retrospectivity in application of these provisions. Hence, these provisions have to be taken as applicable only prospectively to the cases which arise after introduction of these provisions. A bare perusal of the newly added sections 143A and 148 of the Act would show that these sections have been added with non obstante clause qua the provisions of Code of Criminal Procedure, hereinafter referred to as CRPC. The provisions of both these sections have common elements of giving power to the trial court and the appellate court to order compensation in favor of the complainant stroke holder of the check in due course. Further, common element in both these sections is that in case the accused is acquitted, then the complainant would be inquired to return the amount so obtained through the court orders with bank rate interest. However, there are certain striking differences between the provisions as contained in these two sections. Hence, whereas the trial court cannot award more than 20% of the check amount, the appellate court is ordained to award not less than 20% of the fine or compensation. Furthermore, under Section 143A of the Act, the trial court is required to order the accused to pay the said amount as interim compensation directly to the complainant. Under Section 148 of the Act, the appellate court is required to direct the accused stroke appellant to deposit the said amount with the court. Thank you.